on a number of unjust trials in human history. The trial of Sir Thomas More, the trial of Socrates, and even the trial of Jesus Christ. One element characterizes these trials. When you read history, there are trials that are carried out with predetermined outcomes. Those who are taken through the trials are taken through the motions for the sake of it. My learned friend, Mr. Wachira Maina, whom I've had the chance to work with, reminds me all the time that behind every constitution lies a moral idea and a moral expectation that there will be good faith compliance with the commands of that constitution. In fact, Mr. Wachira Maina informs me, and I believe him, that in management theory, there is a concept described as malicious compliance. It informs me that there is a legitimacy gap that is wider than the Pacific Ocean between good faith compliance and malicious compliance. I want to persuade you that the motions that the first petitioner was taken through at the National Assembly and the Senate of Kenya passed the test of malicious compliance. The danger of allowing malicious compliance to go unredressed is that it injects an irredeemable legitimacy gap in constitutional processes. The second inspiration that I wish my lords to bear in mind as you determine this matter was set out by the Court of Appeal of Kenya in the case of Martin Nyaga Wambora and 3 others versus the Speaker of the Senate and 6 others. This matter traversed our entire Superior Court system. I'll have a very emphatic of which particular court I'm referring to when I refer to the Wambora case. So I'm looking at the Court of Appeal 2014. In that matter, the Court of Appeal began by setting out what would inspire it as it writes that judgment. So you look at paragraphs 2 and paragraph 3 of the 2014 Wambora case at the Court of Appeal. The Court of Appeal observes, and I quote, "No parliament, no official, and no institution is immune from judicial scrutiny." I say this because to such other debt as you shall defer us to, some people will take this stand and tell you that there are political issues here that are immune from your scrutiny. The second inspiration that the Court of Appeal set out in the Wambora case was that it is the Constitution, not Parliament, not the executive, not the judiciary, which is supreme. It is the Constitution. I stand here to canvass one substantive question, a continuation of the threshold concerns surrounding the motion, particularly as eventually approved by the Senate. Your brother, Mr. Justice Bahati Mwamuye, has observed in the now famous Kawira Mwangaza case that watering down impeachment, lowering its bar too low, or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. That's the big risk that our constitutional order is subjected to if we allow what happened in this country, culminating into the resolution of the 17th of October 2024, to stand. It's a threat to confidence in our constitutional democracy itself. Allow me just to reiterate one question that has bothered me, and my learned senior colleague, Senior Counsel Paul Mwita, has touched on it. On 17th of October 2024, when you go through the Hansards of the Senate that I will draw your attention to in a short while, the Speaker of the Senate delivered a communication from the chair, an actual ruling, which informed the members that the first petitioner was in fact indisposed and not available to be heard as guaranteed by law. My lords will agree with me, it requires extremely compelling reasons to insist on proceeding with a case where the subject of that trial is indisposed. It must be exceptionally compelling reasons, not just reasons. When you deliver this judgment, because this matter, I've had the misfortune of sitting on the front benches of this case from the time this matter of the National Assembly to the present. This question has disturbed me as a role player in the justice, law and order sector. That the Senate of Kenya, even after the Speaker erroneously, and I use the word erroneously, advisedly, because my learned colleague, Mr. Dudley, will take you through the timelines for impeachment in Article 145, as read at 145. But even after the Speaker erroneously said, we have a timeline of Saturday. They had no such timeline, but the Speaker said so. The senators voted to deny the Deputy President the benefit of those 2 or 3 more days without giving any reason. I would want to read in your judgments, my lord and my lady, through what logic this court will allow that decision to stand, if no other decision, that particular one. That for no reason, we are not saying the heavens will come down falling. We are not saying the country will be subject to any external attack. We are not saying there is any constitutional imperative that compels us to do it tonight. No reason. They simply said, we will not give him the benefit of those 2 days that the Speaker has said we still have. Let's go on record. The Speaker too was wrong. But there may have been some veneer of good faith